So my hope was that we would finish the case late in the afternoon and then bring the jury back the next morning, do instructions, closing arguments, send them out about lunchtime so that they'd have the entire afternoon. It looks like that plan's been thwarted a bit. So I don't have any idea how long Mr. Hankison's going to be on the witness stand. Can you at all ballpark what you think in terms of your direct?
Judge, I would think no more than an hour.
No more than an hour. Ms. Whaley or Mr. Finke, could you just ballpark? And I know that's a tough question, and I'm not going to hold you to it, but just to give me some idea. Would you? 45 minutes? So what is your all's thinking? Do you want to? We could have a short day tomorrow. I mean, we have the jury through Friday. We could have a short day tomorrow, have Mr. Hankison on the stand. We could talk about jury instructions after that. And then we could come back first thing Thursday morning, instruct the jury and do closings.
Would work for us, Judge.
Is that fine with you?
I agree with that.
Okay.
Plan.
All right. So I have a few things on in the morning in court. I think what I'll do is have the jury, instead of come back at 9:30 like we've been doing, have them come back at 10, and we can get started then. We may be able to wrap up by lunchtime.
Your Honor, I have a short motion for directed verdict.
Absolutely. I'm going to, well, we can probably go ahead and do that now. I was just going to say we'll do that after the jury comes back and I let them go, but we still have several minutes, so let me, okay, go ahead.
Your Honor, now that the Commonwealth has concluded its case, I think it's incumbent upon them to have established the basic elements of the crime of wanton endangerment. I'm going to read the statute. I know you're familiar with it, but the statute says a person is guilty of wanton endangerment in the first degree when under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. In order to understand what that statute means, you have to understand the definition of wantonly, which is also defined in that's found in KRS 501.020 paragraph 4. And that definition states that a person acts wantonly with respect to a result or to a circumstance described by statute defining an offense when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that circumstances exist. It then goes on to say the risk must be of such a nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. My first comment, Judge, is that I cannot fathom that the legislators who passed this statute back whenever it was enacted ever envisioned a time when it would be used to charge a on-duty police officer who returns fire at someone who has fired at him or his brother partner and his bullets go astray. There's just no way that was ever the intention of the statute when it was enacted. I think it was more likely enacted to cover situations where somebody is walking down the street and they've got a gun in their possession. They say, let's see if it works, and they go off and shoot it wildly into a house, or for a drive-by shooting situation where a gun is fired at somebody and it misses and hits an occupied structure. That's what wanton endangerment is all about. It's not when a law enforcement officer is doing his duty. But more importantly than that, Judge, when you look at that definition of wantonly, it suggests that in order to be wanton, the actor must be aware of a substantial and unjustifiable risk that exists. He has to have actual knowledge of that risk, as opposed, it doesn't say must be aware of or should be aware of, it says he has to be aware of. which requires that he have actual knowledge of it. And then the actor must consciously disregard that known and substantial unjustifiable risk. Well, here the evidence is absolutely clear that neither Brett Hankison nor his fellow officers knew of the existence of apartment 3 behind apartment 4. So they did not know that they were not aware of any substantial and unjustifiable risk that exists. And beyond that, and Brett Hankison in his statement that was played the other day indicated that he thought they were at a fourplex, meaning he thought there were 2 apartments upstairs because of the 2 balconies, I assume, and two apartments downstairs because of the patios. He had no way, nor did any of the other officers, of knowing what was behind apartment 4. And as we just heard from Myles Cosgrove, and we've heard from other witnesses, there was never any diagram presented to these guys. They were all volunteers who just were sent out to serve this search warrant with no intimate knowledge of what they were getting into. So they were not aware of the substantial and the substantial risk that they were walking into. Secondly, I would submit that in order to consciously disregard a substantial or unjustifiable risk, you have to know it exists. You can't consciously disregard something that you have no way of knowing that it's out there. So that is that part of the wantonly definition that I think is applicable. But then you go to the other part of that definition of wantonly that says that the risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. And I think that leads into the justification statutes that are contained in KRS section 503, because the sections that must be viewed with reference to Chapter 503 would be Chapter 503.030, Chapter 503.040, Chapter 503.050. I'm sorry, I'm saying chapter, I mean section 503.070 and section 503.090. Every one of those is a different type of justification statute, any one of which I think applies to the conduct of Brett Hankison here. They all allow him or justify actions that are done to protect himself or others, which is clearly what the evidence here has established was happening. I would submit, Judge, that if you read those statutes in conjunction with 503.085, that renders Brett Hankison immune from criminal prosecution. That particular statute says if the conduct falls within these statutes, the actor is then immune from prosecution. And I would cite the court to the case of Commonwealth of Kentucky versus William Scott Albright, which is case number 2016-CA-001352-MR. That's an appeals court case that arose here in Jefferson County Circuit Court, and that deals with the immunity that's provided by section 503.085. In short, Judge, I would submit that when you consider all of the evidence, the wanton endangerment statute, and add on top of that the justification statutes, the state has failed to meet its burden that it's required to meet up to this point in the trial. I don't believe the evidence even arises to the level of probable cause to believe that the offenses of wanton endangerment have been committed here. And for that reason, I would ask the court to grant a directed verdict at this time and take this case away from the jury.
All right, thank you. Ms. Whaley?
Commonwealth disagrees with the defense characterization of the evidence and more specifically the statutes cited from 503. Our position is the defendant is not entitled to any of the justification statutes. I don't think there's a single one in there that the defendant hasn't put forward, but 503.040, execution of a 503-090, he is asked for use of physical force in law enforcement. That's actually limited to a defendant who is acting under official authority, making an arrest. So that has no application here. Choice of evils, we disagree with that justification. More specifically, our position is he's not entitled to the justification under either self-defense or defense of another, because as KRS 503-120 subsection 2 states, when the defendant is justified under 503-050, any of the justifications, self-defense or defense of another, in using force upon or toward the person of another, but he wantonly or recklessly injures or creates risk of injury to innocent persons, justification afforded by those sections is unavailable in a prosecution for an offense involving wantonness or recklessness toward innocent persons, which includes wanton endangerment. And we would, when it comes time for the instructions, as we've already submitted the case of Commonwealth versus Caudle, 2018 Kentucky Supreme Court, where based on this statute 503-120 subsection 2, the defendant was not entitled to a justification instruction. The evidence has shown that the defendant, first of all, I'm not aware of any case, statute, rule, or otherwise that exempts police officers from committing crimes in the penal code. The wanton endangerment statute is no different than any other crime in the penal code. If a defendant, layperson, professional, police officer, or otherwise, commits the acts described in the statute, then they are guilty. Firing blindly into the side of the apartment building, into the sliding doors, into the window covered by blinds and curtains, with no target, with no eyes on the threat, is, due to this particular defendant especially, and the amount of training that he's been through for the last 20 years, would obviously, particularly in light of Officer Gelhausen's testimony, the great extent to which the department goes to make sure officers know how to assess a threat, know what is a threat, know that it does require target identification, target isolation before a shot is fired. So the evidence has shown that he is aware of the risk to begin shooting blindly, and that he consciously disregarded that risk when he shot 10 times in the wrong direction into this apartment building. Now, as far as going, as counsel stated, he only thought there were 4. It's clear to anyone looking at the photos and anyone who has been there, there are 4 doors in the lower level facing you at the breezeway of that apartment building. There are 4 doors clearly marked, 1, 2, 3, and 4. In addition, there are 4 doors upstairs, 5, 6, 7, and 8. And in fact, as testimony established, this defendant had a personal interaction with an occupant upstairs who had come out of apartment 8. So it's is certainly not, is certainly Commonwealth's position that he full well knew there was an apartment straight ahead as you're standing in that breezeway with number 3 written on it, back to back, adjacent to apartment 4. For the reasons stated and under the law as the court has established, that the Supreme Court has established, that the trial court is to take the evidence in the light most favorable to the Commonwealth on motion for directed verdict. So we would ask that the court overrule the motion.
All right, thank you. And you did just state the rule, what the court needs to rely on in making the decision whether or not a motion for directed verdict of acquittal should be granted. To draw all fair and reasonable inferences from the evidence and draw those in favor of the Commonwealth. If the evidence is sufficient to induce a reasonable juror to believe beyond a reasonable doubt that the defendant is guilty, a directed verdict should not be given. You know, when you look at the statute 503.120, when under subsection 2, when the defendant is justified under the justification statutes that Mr. Matthews cited in using force upon or toward the person of another, but he wantonly or recklessly injures or creates a risk of injury to innocent persons. The justification afforded by those sections is unavailable in a prosecution for an offense involving wantonness or recklessness towards innocent persons. There's been no testimony that would cause this court to believe that Cody Etherton, Chelsey Napper, or their 5-year-old child constitute anything but innocent persons in this scenario that we have before us. The charge is wanton endangerment, so clearly it encompasses the theory of wantonness. You know, we just recently went to the scene. We saw how close together those apartments are. As you pointed out, Ms. Whaley, and as we've seen from photographs, the numbers are clearly on the doors of those apartments. The officers who went there that night, including Mr. Hankison, knew that this was an apartment building. No reason to believe it wasn't an occupied apartment building. In fact, every reason to believe it was an occupied apartment building because they were there because of a search warrant for Breonna Taylor. So they certainly knew or expected apartment 4 to be occupied. And then, as has been pointed out through the testimony, someone came out of apartment 8 upstairs and had a conversation with Mr. Hankison. So it's 12:30 at night on a weeknight, clearly when you would expect people to be at home in their apartments. We've heard testimony from various officers regarding the shots that were fired from agents from the FBI, regarding the shots that were fired by Mr. Hankison, from the ballistics testing that showed that the bullets, casings came from his gun. We've seen pictures of the shots that went through Cody and Chelsey's apartment, putting them in reasonable fear of serious physical injury or possibly even death as a result of what took place. In reading the statute, the justification statutes do not apply to Mr. Hankison's actions, and so this court will deny the motion for a directed verdict. All right, let's bring the jury. Is Anthony in here? We'll need to get the jury back in. Okay, if you'll bring them back in. Ladies and gentlemen, anything to report from the break? All right, so tomorrow we will gather together again to hear additional testimony in the case. We'll get back together tomorrow morning at 10. I have a few things on my docket between 9 and 10 that I do need to take care of tomorrow. You will hear, as I said, additional testimony. We will not, however, be doing closing arguments tomorrow. And I tell you that because you may want to plan for the day that we have closing arguments and you begin your deliberations, depending on how long you deliberate. And that's just totally up to you, how long it takes you to reach a unanimous decision. You could be here for a while or a very long while or a short while, depending on your ability to agree with one another. So we won't have closing arguments until Thursday. And that's the day that if you have children or pets, you might want to get someone to make sure that they're being cared for, just in case you should be here longer than the normal hours that we have had during this trial. But that will not take place tomorrow. Tomorrow we'll get back together at 10. I don't expect that tomorrow will be a very long day for us in court. So I hope you have a nice night. Please remember the separation admonition. I'll see you tomorrow morning at 10 o'clock.
All rise for the pledge.